The Bombay High Court has deferred its verdict on challenge to Rules 3 (small I) 2 (a) and (c) of the IT Amendment Rules 2023 that mandate social media intermediaries like tend to make reasonable efforts to prevent users publishing information on the government's business identified by fact-check unit as fake, false or misleading. A division bench comprising Justices Gautam Patel and Neela Gokhale is seized of the pleas filed by political satirist Kunal Kamra, Association of Indian Magazines, News Broadcasters of Digital Association and Editors Guild of India. This judgment is likely to be pronounced on January 31, 2024. The petitioners claimed the two rules are ultra-vires sections 79 and 87 (2) (z) and (zg) of the IT Act 2000 and violate fundamental rights under Article 14, 19 (1) (a) and 19 (1) (g) of the Constitution of India. Petitioner Kunal Kamra claimed that he is a political satirist who relies on social media platforms to share his content, and the rules could lead to his content being arbitrarily blocked, taken down, or his social media accounts being suspended or deactivated. The bench had earlier observed that the new amendment to IT Rules 2023 prima facie lacks the necessary safeguards to protect satire. However, the Ministry of Information and Technology has claimed that it would be in public interest for authentic information to be ascertained and disseminated after fact-checking by a government agency (FCU) so that the potential harm to the public at large can be contained. During the proceedings, Solicitor General Tushar Mehta clarified that intermediaries like Facebook, Instagram, etc. are not at liberty to do nothing about content flagged as fake, false, or misleading by the fact check unit. If a social media or news website continues hosting information the government's FCU has flagged as false or misleading, it will have to defend itself before a court if action is taken. The intermediary could lose safe harbor defined under Section 79 of the IT Act, but the final arbiter was the court. However, the petitioners in their rejoinder claimed that intermediaries only have an illusion of choice once something is flagged by the government, because anything short of taking down content, even putting a disclaimer, opens up the intermediary to being sued, Advocate Gautam Bhatia argued. Senior advocate Navroz Servai for Kamra pointed out the lack of remedies available to users if their content is flagged by the FCU as fake, false, or misleading, and argued that the central government is the sole arbiter in such cases and the only recourse for users is a writ petition. During the proceedings, the SG stated that the term information in the rules would be confined to facts. However, Servai argued this was essentially asking the court to rewrite the legislation, which is not its role. He emphasized that terms like fake, fact, and misleading are overboard and result in arbitrariness and discrimination, violating Articles 14 and 19 of the Constitution. regarding the rule being confined to the business of the government. Survey argued that it encompasses a wide range of activities, including those listed in concurrent list of the Constitution, which includes a residuary entry 97, making it exceptionally broad. Entry 97 includes everything under the sun except for 66 items in List 2, survey had argued. The senior counsel strenuously argued why the law on freedom of speech enumerated in Shreya Singh's judgment cannot be overlooked. Survey submitted instances where the Press Information Bureau (PIB) has been called out for putting out incorrect information to imply the government may not always disseminate true and correct facts.